Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Steve Sedberry takes us through a questionably simple trademark license agreement. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I'm here today with my friend Steve Sedberry. How are you today, sir?
Hey, I'm doing great, Mike. Thanks for having me.
Absolutely. I'm excited because I've had a lot of requests for this trademark license agreement that we're going to talk about. That's the document that is the subject today. And it's one of these subjects that it's hard to find people who kind of overlap the nerddom of lawyering and the nerddom of the trademarky stuff. So we're happy to have you talk about it. Let me show this agreement to the folks at home. This one's coming from Law Insider. It's an agreement between blank and Innate Concepts. So it looks like Innate Concepts is who's drafting this. Steve, what is a trademark license agreement? When are we going to see a document like this?
Great question, Mike. This agreement is a bit of an enigma because almost every license agreement that you will see in practice is going to be a minimum of 150 pages long. And this is a 3 or 4 page document. That leads you to kind of ask the question, so what is its purpose? I suspect there could be a number of reasons behind it. It could be an intercompany license. But the bottom line is we think of trademarks and other intellectual property just as we do of any other kinds of real property or personality. It's valuable, and so it's very important to protect it. And a licensor has a legal obligation to take reasonable steps to protect the IP, or you can lose the rights to it.
Gotcha. All right. So in this case, we've got this person who wants to be the licensee. They want to receive this license. They're trying to get the license from the person in the recitals. It says the person who owns police the crease as this phrase. So they're trying to get a license to use that particular phrase. What we're going to do is start at the beginning. If we look up at Clause 1, this is the grant of rights. I'm going to read it because, to your point, it is very short. Licensor grants licensee an exclusive license to use the phrase, the license, on and in connection with clothing and such other goods and services as may be desired by licensee from time to time, subject to the advance written approval of licensor, which approval will not be unreasonably withheld. Pretty basic, pretty straightforward. What do you think about this sentence?
Yeah, it's if I were a licensee, I would love a provision like this because it basically grants unlimited rights. As the licensor, however, it would not be at all practical. I've worked on a number of license agreements, including with some of the most prominent brands in the world, some of the sports leagues, and I'm here to tell you that when they grant rights, you'll have a schedule that might be 30 pages long. I remember laughing because there was one agreement I worked on that had something like 20 different types of T-shirts. You go, a T-shirt's a T-shirt, right? But no, they slice and dice it very carefully, and that enables them to manage their licensee network. So it's really all about monetizing the asset. And for the licensee, it's all about getting as broad a rights as you can. So in any case, the other problem with that provision, I think, is that it is so broad. As I said, this may be an intercompany license or something, but just like with any other corporate matters, if this were to be viewed as kind of a sham agreement, then you could be right back to where you started, which is the licensor has not taken reasonable steps to protect its trademarks.
So let me step you back and ask the basic question. When you say intercompany agreement, are we talking about there's two sub-companies of the mama company and they're sort of shaking hands with each other? They know they're making this deal. What do you mean by intercompany agreement?
Yeah, great question, Mike. So licensors have intercompany agreements for multiple reasons. In some cases, there is a tax advantage to having the revenue streams from the royalties to go into a particular entity. Let's say just, randomly I'll pick a country, Switzerland or the Cayman Islands, where there's a tax advantage. The other reason you do it is if you have a company, let's say, for example, that has a portfolio of brands. You want to make sure that you have papered the right for each division or each subsidiary to use those rights. Otherwise, again, you may have created a sham and somebody could challenge your rights to that trademark and allege that you didn't take reasonable steps to protect it. So, I mean, just to finish that thought, trademark agreements really, I mentioned you can have 100 pages of agreements, which, by the way, they're hotly negotiated. And once you're finished with them, typically, if you've done it correctly, they're going to go in a drawer. And it's never going to be looked at again because that process of forging the agreement also informs both parties what they need to do here. So, in any case, the point of that is to just say lots of reasons for intercompany license agreements, and you have to do them. If you own trademarks and you don't do them and you let your other subs use those marks, you're creating a risk for the value of that IP.
Well, let's jump down to 3 because, again, in our investigating of this particular document, we're going to talk about something that seems a bit unusual. If you look in 3, it says, in consideration for this license, licensee agrees to pay to licensor an annual fee of, wait for it, $100. What do you think about number 3 there?
Well, if I could get rights to Steve Sedberry for Mike Whalen for $100,
Oh,
I would take that deal all day long, and I would make T-shirts and I would make coffee mugs. So that's another, to your point, that is kind of some sort of indication that there's more going on here because every license agreement has a fixed royalty rate. That's a business term, and those are negotiated, and you kind of figure out what the market will bear, and depending upon the value of the brand and the age of the brand and the point in the product life cycle that the brand is in. But you're going to see royalty rates all over the map. I mean, for a big brand, you can see double-digit royalty rates. Plus, it's not just about the royalty rate. It's also about the licensor ensuring that the licensee is not going to just sit on this license. And so any good license agreement is going to have minimum guarantees, which means, so you're going to pay me a royalty, just making this up, you're going to pay me a royalty rate of 10%, but you've got to sell $10 million worth of goods, or else I can terminate this agreement.
Well, let's jump to 4. This is reminding me of, we've done these conversations before about influencers. I'm remembering the Cardi B deal with that vodka company where she was very careful about, hey, you can't just put pictures of Cardi B all over the place. So let's see what the duties kind of are. Under 4, it says licensee agrees to use that mark only in connection with the goods and services, which was defined before as T-shirts, etc. Licensee further agrees to only offer goods and services under that mark that meet the minimum standards and specifications of quality and is otherwise established by licensor. The minimum standards and specifications are set forth or described in the attached rider and made a part of this agreement. It sounds like there's another document that's setting up those kind of Cardi B can't take my picture rules. What do you think about Section 4 there?
I think you just hit the grand slam, Mike, because the grand slam home run, because the standards that a licensor requires, again, it all emanates from that duty to protect the mark. But those standards are extremely specific. Imagine, I don't know, take a trademark like Adidas. 3 lines, right? 3 lines. How can you mess that up? But as a consumer, when you go into a sporting goods store, if they're not real Adidas, anybody would. And by the way, just a real quick sidebar. Counterfeit goods are really just it's the criminal intent version of trademark infringement. If it goes so far to that point, then you can go to jail for it. But if you are merely misusing a mark because you're violating the contract, but anyway, sorry, I'm kind of getting off point, but those standards are typically those that you can define those by 20, 30, 40 pages long. The most important thing is your business people have to understand them. And that sort of leads back to another point about product approvals. So the licensor, in their zeal to control their mark, which they are legally required to do, they set these standards up, and then you, as the licensee, have to submit products to them before you can go to market with them. Well, there's a small problem. I come from the apparel world. Apparel's not made in America anymore, folks. They stopped doing that about the time Congress passed the Textile Products Indemnification Act, and it all just kind of went downhill from there. They're made offshore, which means automatically 4 weeks on the water, right? So I'm trying to come up with a product, but I can't sell it until the licensor has approved it. So how do you resolve that? So that's all tied into, most companies have trademark administrators, the licensees, so that they have a very robust process set up. They communicate with the licensor on a regular basis. Most licensors have portals, and you download designs and you put manufacturers. Some licensors even want to pre-approve your manufacturers. They want to know, and it's contractual. So it kind of goes back to what I said a minute ago, which is the agreement itself may just go in a drawer, but it's the process of negotiating it to make sure everybody has their eyes open. Because let's face it, you don't want to litigate one of these, right? We don't want to find ourselves, because we've got product on the water, we have product in our customer shelves, and suddenly now you've got an injunction that says you can't use this trademark anymore. It forces both sides to operate at an extremely professional level.
But trouble happens, and as is so popular in every contract, it's the indemnities and the hold harmless and all these things to try to push off the responsibility when things do go wrong. Let's look at I believe it's 8 and 9. 9 and 10. So 9 talks about it warrants that licensor warrants that they're the sole owner, that they didn't violate any other party's rights. So it's a bunch of duties for the licensor in terms of making sure that this is clean. The licensee is saying that the licensor will have no liability. You can tell this is written by the licensee. Licensee agrees that licensor will have no ability. Licensee will indemnify, defend, and hold them harmless against any and all damages. It seems like, even though this is sort of written by the licensee, there's a lot of terms that are sort of offloading responsibility in kind of a way that seems to hold nobody accountable. What do you think about 9 and 10?
First of all, I have never in my 20 years of doing this seen a license agreement that was drafted by a licensee. So another on our sort of little investigative quest here, you kind of go, what's this all about? So the licensor normally drafts a very robust agreement, and then the burden shifts to the licensee to prove why you don't need provisions. Indemnities are always hotly negotiated, but I would make an argument. So what do you want from the licensor? You want clean title, I think, as you put it, just like with a real estate title search. Mm-hmm. If you enter into a license agreement and you find out later on that they didn't have the rights that they have licensed to you, you've got a massive problem. So the onus is on you to do the due diligence. In this agreement, interestingly, they specify a registration number. So I'm not exactly a rocket scientist, I play one on TV, but I went to the USPTO database. The abbreviation is TESS, trademark something. Anyway, this trademark is not valid. It's dead. The licensor did not prove use, which you have to do. Again, you can't park on a trademark. So they didn't prove use. They filed a registration statement, spent all the money on that, and they never used it. So it was canceled. If I had entered into a license agreement for this, I would have bought the swampland in Florida and not even had title to it. So back to your point about indemnification. The way you structure this is, first of all, you do your due diligence. You don't normally want to specify the registration number for this reason. There's common law rights. Each state has common law rights. So if you just put the registration number down, then you've completely overlooked the fact that, well, maybe somebody has trademark rights in some other fashion. But what you want to do, in my opinion, the best way to handle this is in the recitals. I know a lot of people say recitals are surplusage, but really they can be legally operative. And you want to have a representation, whereas licensor is the complete owner of all rights and interests to this trademark. So you've assured yourself that there's a chain of title. But what about the title insurance? What happens when something bad happens? Well, first of all, you better make sure that your licensor or your licensee has the financial wherewithal to stand behind this. Ideally, you want insurance and you want to be named as an additional insured. Now, what is the licensor going to indemnify you from? Any claims, liabilities, demands, lawsuits, including reasonable attorney fees. And I know you guys have a million, you've done other indemnities, and so you guys know this stuff better than me, but you want to make sure that if something bad happens, you can hand it off and hopefully get some sort of ability from the court to continue operating. But in the meantime, it's being handled, and you don't have to deal with it. So the licensor indemnity is pure title. There's no challenges to the title. There's no pending litigation that somebody's arguing your ability to use the mark. The licensee, on the other hand, the licensee is indemnifying the licensor because, for all intents and purposes, a consumer. And one quick point: copyright law protects the inventor, and patent law. It protects the artist. Trademark law is different. It's for the purpose of protecting consumers. And the standard you'll hear is likelihood of confusion. So if I make a defective product and somebody gets injured, I'm going to go sue the licensor, right? Because as far as I know, that's who it is. So as a licensor, you need to have a very strong indemnity for any claims, liabilities, demands if something goes wrong with the product. I hope that answered your question, Mike. But that's basically the gist of it.
Sure, and I want to talk about getting out of this thing before we talk about the big picture a little bit, because I've got a story and a question for you. Let's talk about getting out of it. Under 11. It defines the term of the agreement as 10 years. I'm curious to know if that's not, because you're creating manufacturing lines, maybe you need 10 years, but that also seems like a long time. So curious your take on that. But also, it gives the ability to renew the license. It'll be automatically renewed unless, and then there are just ways to get out of it, kind of ways to kill the deal. What do you think about the language under this, the term, and would you change any of this?
Yeah. First of all, just kind of top of my head, you never want automatic. I mean, as a licensor, you never want automatic renewals. You lose track of it. Licensee wants that, but normally it's framed as an option to renew, provided that you are in compliance with all the material provisions of the contract. A 10-year term, never seen that either. I mean, the most I think I've ever seen is maybe a 3-year term. And that's because licensors, they want to be fluid, they want to be dynamic. Most licensors, the purpose of licensing is to extend your brand. So it's kind of an extension of marketing. And most licensors have large departments to make sure that it all foots and ties with what they're trying to do with their brand. Locking something up for 10 years, I mean, you can always, if somebody breaches, you can always terminate the agreement, and we can talk about that if you'd like. But to be stuck for 10 years, and as long as they're paying their royalties, and as long as they're not counterfeiting, and as long as they're not transshipping, you've painted yourself into a corner. And so anyway, I hope that answers your question.
Yeah. I had this experience that I thought of earlier when you mentioned the use of the brands in the Adidas example. I lived in Italy for a little while, and I was in Piazza Navona or something, and they got all the guys out there selling the fake stuff. And I remember there was a Puma logo because Puma soccer stuff is big in Italy. There was a Puma logo, and the Puma had a face on it, like an actual, like a smiley face, like an eye and a face. And if you know the Puma logo, that's not a thing. So I'm going to ask you to do something that you won't want to do, which is argue for a shorter agreement. And the reason I say that is, obviously, if you're Puma and everybody knows who you are and there's a look that you want to be very protective of, those guys using that brand on Piazza Navona with a face on there, that screws up your value. I'm thinking there must be a situation where these kind of broad licenses, hey, take my name and get it out there. It's okay if you sort of screw this up a little bit. We'll figure that out later. Make an argument for a short agreement like this. When would you want that kind of openness and flexibility? Would you ever want that?
Yeah. I think the answer is it depends. It depends on whether you're the licensor or the licensee. To your point, by the way, in my former role as GC of the Americas for a large apparel company, the world's largest apparel company, your story about Puma, it's the same thing. Only in South America, knockoffs are like, they're everywhere, even in legitimate malls. And some of the cultural things, to your point, they don't translate. And if you think about it, it definitely dilutes the brand, right? But to your point, to have a long license agreement, these would be the reasons you'd want to do that. If I were a licensee and I were getting ready to invest a lot of capital in this program, but on the other hand, as a licensor, do you really want to entrust your brand with a newbie? Do you really want to entrust your brand with somebody who maybe is just getting off the ground with licensing? But another reason to do it, I think, would be, you're taking a lot of risk as a licensee. You're going to have a lot of goods. You're going to have a lot of goods on the water. You're going to have a lot of work in process. You're going to have a lot of product in inventory, perhaps. You're going to have goods on people's shelves. And you're going to have salespeople out there promoting these products. So if it goes south on you, you could be out a lot of money or worse. So to have that stability it's like with any business proposition. It's why leases are long term, right? Leases are 10 years long because both sides are happy with the terms, and a tenant doesn't want to be moving around every 3 years, nor does the landlord want the tenant to be moving around every 3 years. But again, it's very unusual because licensors, both for commercial reasons, that is royalty rates, minimum guarantees, all those commercial terms that are so hotly negotiated, the licensor wants to have their thumb on the licensee at all times. But I will tell you, in my experience, the really good ones, so it's normally a renewal, it's a right to renew, but in my experience, the really good ones are very long-term arrangements. They, as a practical matter, they are very, very long-term arrangements because it creates risk to the licensee to yank to the licensor, to yank one licensee and bring in another one. So this is what I used to advise my business people. Yeah, I know it's a renewal, and yeah, I know this and I know that, but you know what? There's a lot of inertia against changing licensees. So long-winded answer to your question, Mike, but the short answer is, in terms of the document, you're not going to see a long-term agreement. In terms of as a practical matter, it's very common. And again, it's because you're making such a big investment in
yeah. And I mean, it reminds me of my litigation days when I would tell parties, you want to pre-litigate so you don't re-litigate, right? Like get the things clear. And to your point, it's not just in the best interest of the licensor in that sense. You also want the licensee to be really clear on expectations and know how to use this so they don't get in trouble later. Well, that makes a lot of sense, Steve. I appreciate you bringing this to us. We're going to go ahead and include a link to this document over at lawinsider.com/resources so that anybody can look at this and other sample agreements. For people who want to reach out to you, Steve, and understand your practice and your thoughts on these issues, what's the best way to connect with you online?
I guess my email would be Stephen at Sedberry, SEDBERRY.com.
All right, we'll make sure that link is at lawinsider.com/resources as well. And if you want to be a guest on the Contract Teardown Show, please just shoot me an email. I'm at community@lawinsider.com. We would love to have you. Again, Steve, thank you, and we will see you all next time.
Thanks, Mike. It was a pleasure, and really enjoyed talking with you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.